All right, I think we're ready to begin. Good morning. This is an oral argument session of the 5th District Court of Appeal. I'm Judge Rick Orfinger. I'm joined on the panel this morning by Judge John Harris and Judge Jamie Grosshands. We have one case this morning, Tanya Rossman as personal rep of the estate of David Rossman versus Robert Wallach and others. Both sides have 20 minutes. This is being recorded and broadcast on YouTube and will be archived on our website. If the appellant wants to reserve something other than 5 minutes, let us know and we'll try to adjust the clock. But when the clock starts to flash yellow, you're into your rebuttal time. Both sides have 20 minutes, and with that, we'll ask appellant's counsel to proceed.
Yes, may it please the court, Your Honor, Dale Scott for the appellant, and I would like to reserve 5 minutes, so it looks like there's not much that needs to be done. We're here on what I believe to be a rather simple issue on appeal, and that is really one which relates to summary judgment process and the process by which a trial court may rule on a summary judgment motion. The facts are in many ways undisputed in terms of what happened boots on the ground with this unfortunate incident where my client's husband was killed in an industrial incident where he was crushed in a baler, cardboard baler, that is. The issue that arose, though, and the reason we're here is because when this case went forward with the defendant's summary judgment motion, they asserted pretty clear grounds for summary judgment, and that is that Mr. Wallach, who's individually sued under count one, he argued that he can't be liable and that he was entitled to workers' comp immunity under the provision of workers' comp immunity under section 440.11, which says that a manager or supervisor is entitled to comp immunity unless they are acting in some way which violates law and carries a penalty greater than 60 days. If we back up a bit, what we alleged in the complaint and the count we asserted was what is sometimes referred to as fellow immunity liability or gross negligence or willful wanton liability. And that says that a co-employee to an injured or killed employee can be sued if it is determined and if it is proven that that individual, that co-employee, acted with gross negligence in carrying out his or her duties, and that action resulted in the injury or death. We alleged and asserted that indeed Mr. Wallach acted with gross negligence with regard to pressing the button, activating the baler at issue, which resulted in the death here.
Can you be both a co-employee and a manager at the same time?
I believe you could be hypothetically a co-employee and manager at the same time. And I'll say it like this. We, of course, acknowledge that Mr. Wallach was the boss. He was the owner of the company or the head of the company. But what's key here, and this really is key more with regard to our cause of action and the actual arguments pled in the summary judgment or argued in the summary judgment motion. Now, I'll get to in a minute the fact that what the court ruled on isn't what was actually argued in the summary judgment motion. But in a situation like this, we have the boss essentially coming out of the control room and getting onto the factory floor or the facility floor and engaging in the work itself. You know, as I was driving here today, I was trying to think of an analogy, and the best one I could think of was, I know back many years ago in baseball, you used to have managers who were also players at times. They would manage, I think Pete Rose may have done that. He was the manager. He decided what players would play where. He decided what pitchers would go in. But occasionally those managers, I don't think they do it anymore, would actually go up to bat sometimes. It would actually take the field. Here, this is a situation where the manager, the boss, the supervisor, he decided to take the field. And he went onto the field and he took an action of what we call, or what I referred to as an ordinary worker. I don't know if ordinary is the right term, but what the case law has laid out, especially the Hawkins case, which this court has cited to in the past, is that the distinction really is operational and implementation versus planning and decisional in terms of what managerial and activities.
So if he made the decision that that conveyor needed to start running again, what's the difference between him yelling down to an employee, hey, push that button, or him coming down to push the button himself? The managerial decision was, I want to get this thing moving again.
Well, he made both decisions because the implementation of that decision would involve the very actions and would involve the very things that which he didn't do, and which led to Mr. Rossman's death. You're right. It's one thing to yell down from the control room, get the conveyor running, let's go. But then at that point, it would be up to the worker on the floor and the employee on the floor to actually go through the protocols, make sure everything's set up, make sure the machine's primed, make sure everything is in place to get the machine actually running. That is true implementation of what would occur here. But also, as an aside, these are the very issues, and I'm already, and I do this a lot, I'm already jumping around a bit, but these are the very issues that would have been discussed with Mr. Wallach during his deposition. These are the very things that would have been considered and discussed in terms of points of fact, which would have affected the actual question of whether he was acting as a managerial employee, managerial capacity versus employee implementation capacity. So, and that's one of the errors that we've raised on appeal here, and that's something that certainly is of key importance. But you're correct. I think you can have the boss who is the boss for one status, but once he enters the ring, once he gets on the factory floor and he does that action, he takes on that fellow employee status. And that's exactly what we pled here.
How do you distinguish this from the facts in the case of Woodson v. Ivey, where we said that it was clearly a managerial decision to send the decedent back to the shop, and how that was accomplished was not really relevant?
Well, I don't know that case is...
The decision here to turn on the line, to get the line going, the machine going, how that was done, whether he pushed the button himself or yelled down to one of his guys, get the machine going, is that relevant?
I think if I understand Your Honor correctly, I believe the cases are distinguishable in the sense of, well, of course, the big issue in Woodson was the motorcycle and whether the fact that it was a personal motorcycle really played into the decision there. And you're correct in that in that case, the legal decision was made that it wasn't the mode of whether it was a personal motorcycle or whether it was a business motorcycle. It was the fact that he was accomplishing a business purpose, the boss is, that is, by having that action done. Here, the distinction, I believe, again, would be the fact that it went beyond merely the making of the managerial decision. And I'm trying to think of an analogy of how that may have played out in the Woodson case. For example, it may have been if the boss had been driving the motorcycle, or if he had committed some act of gross negligence with regard to maintaining the motorcycle, or how it existed there for the worker to use. Here we have a separate issue that wasn't at issue in Woodson concerning the actual implementation of the act at issue, which would have involved the steps needed to activate the baler. And as we've argued in our briefs and as we've shown through the OSHA documents and other documents, there were significant problems with what was done in that respect. It's quite clear when you read the briefs and when you read the papers, of course, that the lower court did not rule on the grounds that were actually argued at the summary judgment hearing. That were
Counsel, let's say that we agree with you, hypothetically, that the grounds on which the court ruled were not the ones argued below. Can this court then make a ruling as to those grounds? So could this court find that summary judgment was appropriate as to the grounds raised, as to the managerial exception?
No, I don't believe you can. And that whole question is the tipsy coachman question, which I've, of course, had come up many times in litigation, which has confounded me many times because it's confusing. And I think some of the courts are, respectfully, I'd say the courts and myself are confused. But the reason you can't rule on that is because the distinction is that the grounds here on which the court ruled, the lower court ruled, were not asserted in the written summary judgment motions. And what's more is that in terms of development of the factual record, the court did not reach any findings of fact as to the actual grounds that were asserted in the motions that were filed. That is, if you read the order, there's no finding of facts, there's no consideration in
But in a summary judgment motion, the trial court they're not sitting as a fact finder. I mean, that's kind of the whole point of a summary judgment. is that they're not fact finders. If they were, then now we have a problem with the summary judgment. So why would this court not be in the same position, so to speak, as the trial court in reviewing where, as a matter of law, does that managerial exception apply?
Well, I would first say this. I have not as much difficulty with consideration of whether the exception applies. I believe the facts that are now in the record, which weren't in the record when the summary judgment hearing happened, showed that there is clearly a question of fact as to whether the action was taken in terms of managerial or fellow employees. So I don't want to make it seem as though I'm avoiding that question. In fact, I would have been happy to, or was happy to argue that question and did argue it. But I believe the distinction lies in the fact that there was not a development and there was no consideration in rulings and findings of fact or development of the record in terms of that argument as to in terms of what the court actually ended up finding. In the case law, as I reviewed it and I understand it, requires some degree of finding of facts, some development of a record below on which the court would rule on that issue. And that would include the order itself and what the judge was considering. But I do believe the facts as presented and as argued at the hearing show that this individual was acting as a fellow employee when that incident happened. And that's exactly what was argued. That's exactly what was considered at the hearing. The real issue is the question of whether you can affirm on the argument that, well, this didn't rise to gross negligence. And that was a summary judgment order that was entered by the court. And that's what we of course had to appeal. But we were happy at the time and remain happy to have the argument over, okay, was this an act of gross, was this a managerial act or was this a fellow employee act? There were other errors and other problems in the proceedings below. One was, of course, that discovery remained open. This hearing happened in January. I believe trial was set for April. We attempted to set depositions, and I even got it wrong in one of my briefs, in that I think I say that we tried to set the depositions after Mr. Wallach filed his summary judgment motion. That's actually not correct. We tried to set his deposition before he ever filed a summary judgment motion. I would respectfully submit that we had some difficulty in setting those depositions, but we ultimately got them set. And those depositions were set and pending when the court heard and when the court we went forward on the summary judgment motion. Now, I know the court mentions and the opposing party mentions the fact that we canceled those depositions. And as I pointed out in the briefs, we canceled them at the request. And as the emails and other things that we filed show, we canceled them at the request of the other parties who said they weren't available. And by the time we would have gotten around to rescheduling them, the lower court had already issued the summary judgment ruling. We believe this case really hinges on Rule 1.510 in the summary judgment process and proper notice and proper due process, which applies in cases like this. If you really boil it down, what happened was we walked into a hearing. We were ready to argue one issue of law, one particular issue of law as raised. We got to the hearing, everybody argued that issue of law. And then a few weeks later, we got a summary judgment motion that decided not on that issue of law, but decided on an issue that wasn't raised in any of the motions, in any of the pleadings that were heard at the hearing. We respectfully submit that violates Rule 1.510 and requires reversal. I think the other, perhaps the final argument to be addressed is there was an accusation that we in some way invited a discussion or invited a ruling on the gross negligence issue. I haven't been able to identify where in the record I asked the court to issue some kind of ruling as to count one without going to trial. That, of course, count one and all the counts we believe would be questions of fact. We wouldn't ask for the judge to issue a ruling on that. If this summary judgment is allowed to stand, we believe it would stand for the proposition that at any point in a proceeding, a judge could simply decide whether on a motion to dismiss, motion for summary judgment or otherwise, to decide on an issue in the case and issue an order. I mean, here, that ruling as to whether it rose to the level of gross negligence, it was issued in the context of a summary judgment order. But bearing in mind that the summary judgment motions and the summary judgment hearing and the summary judgment argument didn't raise those issues and didn't concern those issues at all, it's as though the trial court simply decided on its own that it would rule on the case and decide the case. Now, I would decided incorrectly. We submitted the after hearing evidence, which we would have submitted before the hearing, which clearly shows, I believe, that Mr. Wallach was indeed grossly negligent in terms of his actions. We gave the pictures of the ladder and the OSHA evidence, and the ladder which shows the control panel and the box was open.
Well, what is your best contention or your best argument that summary judgment was not appropriate as to RWA, not Mr. Wallach individually, but RWA? I understand there's issues that could arise as to Mr. Wallach, but what about RWA?
Well, RWA, I believe on the same basis, summary judgment would have to be reversed. But simply the arguments weren't fleshed out in terms of what would support or rebut possibly any grounds that the lower court ruled on, because the lower court didn't reach any conclusions of fact or record findings or even conclusions of law. It simply said, well, as I'm finding in favor of Mr. Wallach, the individual defendant, as to count one, and respondeat superior must necessarily concern or be hinged off of a claim against an individual, summary judgment's due. But I would say the Hunt case, just to drill down a bit more, the Hunt case, which describes that indeed an individual or a respondeat superior claim may be based or may be asserted where one of the exceptions applies, that would probably be our best case. To answer your question directly, Your Honor, and I'll reserve my time if I may.
All right, counsel, thank you. All right, Mr. Macelli.
Yes, Your Honor. Good morning. Richard Macelli on behalf of Appellees Robert Wallach and Robert Wallach Associates. May it please the court. First and foremost, Judge Orfinger, you cited to the Woodson versus Ivy case, which obviously you recall writing about 15 years ago. You wrote the decision on that. It's pretty crystal clear that I think that's the controlling case with regard to the management decision that was made by Robert Wallach. The focus there was not necessarily on the means by which things were executed, but was it through a business purpose? At the very beginning of—
Though that your summary judgment motion didn't raise that issue, the management, excuse me, didn't raise the gross negligence?
Yes, Your Honor, and certainly we do not argue that. I think our argument, as we outlined in our brief, was that, and this is not one of the cases that I think was cited by the appellant, that there was an ambush, that somehow at the summary judgment hearing we all of a sudden ambushed counsel with new arguments. The reality is that the judge did render an order analyzing gross negligence and finding that it did not apply. So obviously the record and the order speaks for itself, and I'm not certainly agree with you, Your Honor, that the judge did an analysis of gross negligence. I think the
basis for doing that, it seems, Mr. Macelli, is he finds in the order that the defendant's alleged summary judgment should be granted, one, because of the immunity, and two, because the plaintiff failed to allege gross negligence. Is that anywhere in the motion for summary that the plaintiff failed to allege gross negligence? The judge said it's in the motion, but I can't find it in the motion.
No, Your Honor. I don't think we argued the managerial and obviously the question of law regarding RWA, Robert Wallach Associates. So I do think, Your Honor, that the analysis that was provided by the trial court was an analysis that under any scenario, if you don't have gross negligence, you don't even have to get to the issue of whether someone's a manager or a co-employee. And so that being the lowest common denominator, by making the determination that there wasn't even gross negligence, you don't even have to reach the question of the status of the employee. Obviously, Your Honor, in this case, Robert Wallach, who
normally would find gross negligence.
I'm sorry, Your Honor?
Who normally would find whether there was gross negligence?
That, Your Honor, can be a question, I would say can be disposed of and is disposed of at summary judgment by courts. I think at the very beginning it was telling, and we've seen otherwise throughout the briefings, that the facts issue are really not an issue. We know what the facts are, and that in this particular instance, they've been developed through discovery, through interrogatories, through an affidavit, through a 1,000-page OSHA investigation. So I think, Your Honor, one of the things we heard later in the argument was, well, he didn't get to depose them, what they would have developed. But Your Honor, the deposition, what the questions would have been asked, those are already developed and before the court on this record. And so that aspect of it is pretty clear that in this particular instance, Robert Wallach, the president since 1976 of Robert Wallach Associates, after, again, in the supervisory capacity, supervising the floor and looking around, trying to find out where Mr. Rossman was, after asking the employees and being told that he was potentially in the bathroom, and looking around and otherwise being aware of the circumstances, he made the judgment call, the management call. It was his call to make to start work that day. And that's certainly within the realm of what he was entitled to do as a manager or a officer of the company.
But
Very
the
much
judge-
like in Woodson versus Ivy. There's no
that-
question that this was a business decision, and a lot of the cases that were cited by the appellant, there's questions of fact as to whether or not it was a business decision. There's no issue of fact on that, Your Honor.
Counsel, I think that the question here, though, is that is the argument that you made in your summary judgment motion, that he was acting as manager. That is not necessarily what the trial court based that ruling on. And I think that's what Judge Harris is saying here, is that there's a disconnect there between what potentially the party came in, the Rossman party came in to argue what they thought they were going to argue, and versus what was actually the basis for the ruling. Let's say we agree with that contention, that was, not proper on the part of the trial court. I'm going to ask you the same question. Can this court find the managerial exception applies in summary judgment? Are we in the same place as the trial court to make that decision?
Absolutely, Your Honor, and that's the Landis decision that we cited. This is a well-developed record. There's literally thousands of pages between the OSHA file, through the interrogatories, through the discovery that was conducted to analyze and understand exactly what this particular decision was. And it's important, Your Honor, in the Woodson versus Ivy case, the procedural history of that is a summary judgment was filed on the issue of whether it was a management decision or not. That was denied. It went to trial. Ultimately, the jury found for the plaintiff. And then on appeal, the appellate court analyzed it. And again, Judge Orfinger authored the decision and determined at that point that it was a management decision, and that therefore the manager enjoyed the same type of immunity that the employer would. And so, Your Honor, that's obviously, I think, the controlling case here. And between Landis and what we see with Woodson versus Ivy, there's certainly the authority and the ability to make a ruling here on this de novo review as the Landis case determines. And that's also appropriate for summary judgment cases. And that's cited again, I believe, in the Landis case. So this court does have the authority and the ability on the facts as they're developed, determine that, yes, there was a management decision. And that ends the inquiry regarding Robert Wallach, because there isn't any virtual certainty arguments or anything that it would be higher than the gross negligence argument that ultimately on page 12 of the plaintiff's response to our motion for summary judgment did do an analysis of gross negligence. And that dovetails into our argument that, yes, there was an injection of gross negligence by the plaintiff in the underlying proceedings, wherein the judge, I think, took that argument and then analyzed it and said, under even the lowest standard that you could possibly have liability, the gross negligence standard, I'm finding that you don't even reach that level. So we don't even get to managerial level. So
let me ask you about that part, Mr. Because that concerns me a little bit as well. He said the facts do not establish gross negligence, but then he goes on to say that it's a composite of these facts do not indicate that Wallach knew or should have known. What does composite mean? Is he weighing the evidence?
No, Your Honor. I think ultimately what you're looking at is all the facts that were submitted. And again, this isn't a situation like it's a motion to dismiss. And I think that was one of the cases that we have been argued. This is at the summary judgment level after a good amount of discovery had been done. And so under that particular circumstance, and also, Your Honor, the thing that we have to realize is we are under the framework of workers' compensation and workers' compensation immunity. And the exceptions to workers' compensation, as the court well knows, are narrow, very narrow. They're extraordinary. And in most instances, it's appropriate for courts to rule on summary judgment, even under the gross negligence standard. And so that it can't be lost on that this is supposed to be an alleged exception to.
But can they rule after weighing the competing evidence from both sides? Is that
I'm sorry, I missed the first part. I'm sorry.
But can the judge rule on gross negligence after weighing the competing evidence at a summary judgment hearing?
Well, Your Honor, I think depending on what that evidence, the arguments are, in most instances, I think in this particular instance, even on the motion for rehearing, there really wasn't competing evidence that this rose to the level of gross negligence. And so on that ground, Your Honor, I think that it isn't weighing the evidence, that it actually looking at the facts as they are, and they're well developed, even though I know there's an argument that Mr. Wallach's deposition should have been taken. But, as an aside on that, Your Honor, I think that being under a different standard, the abuse of discretion standard, I won't spend too much time on that, but I think that argument falls very well short of the mark, given the amount of time that this case was pending, given that a summary judgment motion was filed and that there was plenty of time before the hearing actually occurred. And regardless of the reasons, to have the in this case, the plaintiff cancel the depositions and not even pursue them while a summary judgment order is pending, I think speaks volume. I think actions speak louder than words, and the actions or inactions here show that these depositions wouldn't have changed the analysis one bit. We respectfully, Your Honor, the judge got it right on the gross negligence determination. But that being said, we submit that this court could also determine as an alternative that the managerial decision that was made would ultimately rise it to even the more culpable negligence standard. So there's multiple ways in which this court can affirm the decision down below, or in writing its own decision, can determine through the Landis case that through its own de novo review, that looking at the facts as they're developed, that summary judgment should have been entered for a variety of reasons. Number one, no gross negligence, as the court determined. And number two, with regard to Robert Wallach individually, that it was a managerial decision. And there's really, because one of the things that's telling about, the fact that in most instances with the Spolsky case, if you're complaining about not having discovery, you have to file a motion to continue the summary judgment. You have to identify what information you need, what steps you've taken to do it, and how that would affect the analysis. That's completely, there's nowhere in the record is there those arguments made. And so, Your Honor, what we're left with is well-developed facts through affidavits, through interrogatory responses, through a 1,000-page OSHA report where Mr. Wallach was interviewed. And all that being said, we come back to the same conclusion that ultimately, and I think, it's pretty compelling, as Judge Orfinger pointed out, in the decision in the Woodson versus Ivy case to have the employee drive the motorcycle, it may have been a poor decision, as Judge Orfinger put it. This court could determine, well, it may have been a poor decision for Mr. Wallach to go forward with pressing the button and from a management perspective, but that's at best is negligence. That's not gross negligence. There's no analysis that there was a known danger. There's no analysis or any facts that would suggest that.
Mr. Macelli, isn't the risk of if somebody's inside the machine, isn't that danger known? I mean, Mr. Wallach, who's been doing this for many years, can't really credibly say somebody's in there or somebody's got their hand in the machine and it gets started, there's no danger there. I mean, I looked at the OSHA stuff and all the stickers that were on the machine about the danger of falling in. I mean, this is a pretty dangerous piece of equipment.
Your Honor, obviously, in the analysis, whether it's a car or some other piece of equipment, I think that's so. But I think, for example, in the pug mill case, and I could cite to that, where the employer knew that the person had to go into the pug mill, which was a cement mixer, and clean it out, and knew that they were in there, and that they were cleaning it out, and through some miscommunication, then actually turned the machine on. That highlights the difference of that case versus this case, where in instance there was nothing to lead any knowledge on behalf of Mr. Wallach that he knew that Rossman was in there. There was no.
I'm not suggesting that. You said that this wasn't a known danger, and I'm just saying that this machine seems like it's inherently dangerous if somebody's either inside it or has their hand stuck inside of it. I mean, it seems just obvious. I don't think that Mr. Wallach can credibly say, I didn't know it was dangerous if I start the machine with someone in it. I can understand he said, I didn't think there was anybody in it. But isn't this machine of such a nature that it is inherently dangerous if somebody's inside it?
I would agree with that, Your Honor. But the operative aspect of this is that there was no knowledge that Mr. Rossman was in the machine or anywhere near it. And after asking and calling around, asking the employees and being told that they thought he was in the bathroom, that's
Mr. Scott points out, if Mr. Wallach knew that Rossman was in there, we have a whole different case. It's whether there were circumstances through which he could have or should have known, such as the open hatch at the top and the ladder where it's not supposed to be leading up there. Could he or should he have known? It's not whether he knew.
Well, and under those circumstances, Your Honor, there was never an instance where it was contemplated that the employees would be in the machine, working on the machine. So that was certainly outside the pale of anything that, in this particular case, Mr. Wallach would have anticipated. And again, from the prism of looking back on it now, which obviously we can't do, we look at it from the standpoint of what he knew at the time. And in his management decision, which again, I come back to that, is that, he made the judgment call as a manager to move forward and start work that day based on the information and facts that were known to him. And since that ultimately was his prerogative to do that as the manager owner of the company, that he made, in retrospect, made the wrong decision, obviously, but looking at it from the parameters of either culpable negligence or under even the lower gross negligence standard. And again, argument is that he's not a fellow employee. He's obviously a manager and a supervisor. So the proper standard is culpable negligence. And I don't think there's any argument that he would rise to the level of that. And quite frankly, Your Honor, I don't think there's any fact issues that would lead to the argument that he was grossly negligent. Now, did he make maybe a poor decision, as the poor decision was made in Woodson versus Ivy? But ultimately, that doesn't rise to the level of gross negligence.
Counsel, how if this court were to say that managerial exception was a question of fact and should be looked at by the fact finder versus a question of law, what does that do to the RWA?
Your Honor, I think I'm quite frankly shocked at RWA in this case, in the sense that they clearly, under the statute, the only cause of action that's been lodged against RWA is a vicarious liability argument. And clearly the statute in the first line of the statute says including vicarious liability. And so, and respectfully, there's not a whole lot really addressed by the appellant in that. And I think that's kind of maybe a concession on that. I mean, the only thing they point to is this Hunt case, which that's the separate works argument. And that applies to fellow employees. It has nothing to do with the employer. And so that is a question of law. So all these other arguments about whether more discovery should have been done and all, that doesn't apply to RWA. RWA clearly was entitled to summary judgment. And either through the analysis that the judge provided, or again through Landis, and that this court through a de novo review can on its own make the determination that RWA is not liable for vicarious liability. That's just the law in Florida. And I know there's some arguments. We cited the Vallejos case, but that's on point, Your Honor. That's really crystal clear that RWA is entitled to summary judgment, because again, bears repeating, the only count against RWA is a vicarious liability count. So that I don't want to spend too much more on that, because I think that's a very clear determination on that. But in closing, there are multiple ways in which this court, through a de novo review and through the Landis decision, can determine, number one, that there was a management decision made, which obviously raises the culpable liability standard, which is not alleged and can't be proven in here. So that's clearly could be determined by this court. And secondly, you look at the gross negligence standard that was that through an analysis that the court did do, they determined that in fact gross negligence was not met. And again, I would submit that the analysis there was to cut off any argument that you would even have to argue that there was management liability. The judge took even the lowest standard that the plaintiff had to show and determined that no, they don't even make that standard. And again, it's within that backdrop of workers' compensation immunity. Benefits have already been paid. There's no issue regarding that. That analysis was set forth. And so you're really looking at a situation where, is there an exception to immunity, either through the gross negligence standard, but we would submit the proper analysis would be through the employee supervisor standard. So under that backdrop, and including the Woodson versus Ivy analysis, where again, that backdrop is the employer and the employee in this particular instance are entitled to summary judgment on workers' compensation immunity. Thank you.
Thank you, counsel. Mr. Scott?
Yes, Your Honor. The difficulty with going, and we've discussed now tipsy coachman quite a bit, but even going beyond that is the questions of whether the claim would be proven up as a gross negligence claim ultimately, and then the affirmative defense of whether they can escape, or Mr. Wallach can escape that claim by arguing, no, I was a fellow employee who might be subject to that exception, but I was a manager. Those are all inherent questions of fact. They get into the actual questions of what was going on, what were the actual activities, and what occurred. The fact that the basic pled facts have been admitted to doesn't create or doesn't remove the question of fact as to those questions. Was he grossly negligent versus negligent? Was he a manager in a manager capacity versus a fellow employee capacity? And you know, one of the ironies that it has suddenly occurred to me is that for purposes of summary judgment, they conceded that all of the pled facts are true. Well, the lower court had previously considered those pled facts and motions to dismiss and found that count one, the gross negligence claim, stated a cause of action for gross negligence. So it has suddenly dawned on me the somewhat inconsistency of saying, well, we admit all the facts which support a cause of action, a valid cause of action for gross negligence. But now in summary judgment, we're going to find that gross negligence hasn't been proven out. That seems a bit inconsistent. And again, as to those questions of fact, discovery remained open, depositions were pending. Those things will be fleshed out. So even if we employ tipsy coachman in some way to get past the pretty clear procedural problem that the court waded into, it still is a question of fact. There still cannot be affirmance on the managerial ground. And as we've discussed, we think the facts actually show, or the facts that we do have in the record actually show, this isn't the manager in the dugout deciding the lineup. He picked up a bat, he picked up a glove, he went on the field, and he was playing. There's a very clear distinction, and he admits the same. You know, finally, I would just say in terms of, you know, it was claimed, this opposing counsel claimed that I was ambushed at the summary judgment hearing. That's actually not what I'm claiming. What I'm claiming is the ambush came after that, when I got the summary judgment ruling, when I saw for the first time the grounds that the court was going to rule on. And that is when I put into the record all the evidence of gross negligence, all the pictures, all of the OSHA file, the Winter Garden file, all of the things, even statements from witnesses who say that ladder is only there if somebody's working on getting a jam out from underneath the, or from within the machine. So I think the evidence, remembering, I don't need to remind you all of this, of course, but all of this needs to be construed in a light most favorable to the non-movement, to the plaintiff. And so we're looking at, evidence of a ladder, of an open panel. This guy's the one responsible for clearing jams. Nobody can find him. And a jury could find that that is an act of gross negligence. And in the end, it is for a jury to decide. I mean, that statement from the order was somewhat, I'll say this, surprising to me, that based on a composite of the circumstances, I find this case, or the claim doesn't rise to gross negligence. Whether a claim amounts to gross negligence and the weigher of composites of circumstances, that's for the jury to do. That's for the jury to decide, to hear all the evidence. It may very well be a jury question on the form. Was this individual acting in a managerial supervisory capacity or in the capacity of a fellow employee? That seems like likely a very reasonable question to be on the jury form, as is the question of, was he acting with negligence or was he acting with gross negligence? Those are inherent jury questions. Those are facts to be fleshed out. The court committed reversible error in deciding on grounds that weren't asserted in the summary judgment motion, but we believe this should be reversed and remanded back for further proceedings. Thank you.
All right, counsel, thank you both. That'll conclude our arguments for this morning, and we'll be in recess until our next session. Thank you so much.
Thank you for your time. Thank you.